I spent 5 years as a district attorney, and during that time, I prosecuted literally thousands of DUI cases. And everything from simple misdemeanor, run-of-the-mill DUIs to DUIs with injuries to vehicular manslaughter cases to actual murder cases where someone caused an accident and somebody got killed and we charged them with murder. So I prosecuted thousands of these DUI cases. Later, I resigned from the DA's office. I became a criminal defense lawyer, and now I have a firm where we focus on representation of citizens who are charged with DUI. And I want to talk about a prosecutor's perspective because so much of what we do as DUI defense lawyers is negotiating with district attorneys and city attorneys and trying to convince them to reduce charges, to dismiss cases, to agree to lesser sentences, to get good deals for our clients. And if it doesn't work out, if we can't work out the deal we're looking for, then the alternative many times is to take the case to trial. But if we can negotiate with the prosecutor and get a good outcome that our client is happy with, without the stress of a trial, oftentimes that's the best thing for our client. Now, a prosecutor really looks at a DUI as being a liability crime. And that means that they're always worried about recidivism. They're always worried that this drunk driver is going to go out and do it again. And that there's a responsibility to hold him accountable this time. And I remember in our training session, the first week as at the district attorney's office, we had a speaker who was a high-level DA, and he was talking about this. And he said, you don't want a situation where you dismiss a DUI case, and a couple weeks later, the guy goes out and he gets drunk, and he gets back in his car, and he kills somebody, and it's on the front page of the LA Times. And the reporters come to you and say, why did you dismiss his case a few weeks ago? Why did you not hold him accountable the first time? Make him go to DUI school. Make him do some jail time, perhaps. Make him face the consequences. So that's always in the back of the mind of a prosecutor, is the liability that they might face, personally, and judges too, for that matter, that they might face personally if they're too lenient on someone who's charged with drunk driving. Moreover, a lot of prosecutors are true believers, and they really have sort of a personal thing against drunk driving. And I remember my first assignment in the DA's office. I had a supervisor who was like this. And there was a big poster of Mothers Against Drunk Driving in her office. And she would go to lunch with victim advocacy groups and with people from MAD all the time. And she hated drunk drivers, and she felt like she was on this sort of personal mission to get them and to hold them accountable and to bring justice and to sort of protect the safety of the community. So there are a lot of prosecutors and there are a lot of judges like that they never want to give a good deal. They never want to give a break to a drunk driver because of their own politics and their own personal philosophy. But all of that said, at the end of the day, no matter what their politics are, the prosecutor has got to prove the case beyond a reasonable doubt in court. And ultimately, that's going to be proving it to a jury. And the prosecutor has to convince every one of those 12 jurors that the defendant is guilty. And if even one of those jurors has the reasonable doubt and doesn't want to go along, then the client can't be convicted. So our job as defense lawyers is to find those problems in the case that are going to give the prosecutor misgivings. And that may be problems with the blood analysis. That may be problems with the way the breath test is administered. That may be mistakes that the police officer makes in his investigation. That may be discrepancies between what the cop says in his police report and what he testifies to at the DMV hearing. There are all sorts of issues that we find in a typical case that really accrue to our client's favor. The more we can find these problems in the case and document them and bring them to the prosecutor and the judge and show them that there's weaknesses in the case and that a not guilty verdict is a definite possibility if the case goes to trial, the more willing we find prosecutors or judges to be to reduce charges or agree sometimes to an outright dismissal.